I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are courtroom hopping back into the courtroom of Judge Pauline Freund for the case of Mr. Sylvester Evans. This is going to be our third and fourth time in her courtroom and what looks to be the conclusion of this case. So just like many of you that have been following this case, I am looking forward to seeing how this all plays out. If you have not seen the previous cases, you can check those out on our channel. And with that being said, guys, let's jump into this proceeding.
We are on the record. Thank you for asking.
Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on
You don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
I'm not going to do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates.
Correct.
Which will prolong my time in jail.
I don't know that.
Possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail. I'll do my best to work with this guy.
Okay.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for.
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send two different letters?
Yes.
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
You'll have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send one letter. They in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, can you tell the jail, give me sufficient paper so I can make two copies? Because they're not giving me what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati and then he can make copies for both the court and the city.
Okay, Mr. Ionati, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionati.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. McCoy Sr. He believes that they're all witnesses for this case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ionetti if he's doing
Sir, you can't get restitution. I mean, I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal, there's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
No.
And not even my rights as a tribal chief.
You have asserted that you are a tribal chief. I have seen no evidence of that being true. Just because you say it doesn't make it true.
I gave you the proof, but you needed the physical case in front of you, which has a seal on it. So even if it's in front of you, you still won't be able to see that I'm a tribal chief based on having a case in front of you.
It's my understanding that Mr. Ionati was able to obtain that document.
Correct, which is a matter of secret state privilege.
So you can't say it's in this document and then not let me see it.
I'm just stating facts. That case is a matter of secret state privilege. So that would be grounds would that be grounds to get it transferred to federal court?
The issue is whether you trespassed at the airport, sir. That's the only issue.
I understand, but as a tribal chief, I have the right to have any grievances between me and the state heard before the United States Supreme Court due to me representing a sovereign state that's federally and internationally recognized, a sovereign tribe that's federally and internationally recognized.
You won't tell me the name of the tribe. You won't show me the document.
It's a matter of secret state privilege, Your Honor.
You can't have it both ways.
I'm just stating facts. It's a matter of secret state privilege.
So no, as I understand it, the city is not willing to transfer this case to federal court.
Mr. Ionetti, I would like to appeal anything that's being declined. I just want to get this on the record that I want it appealed. Anything that's being declined, I want it appealed.
Sir, you represent yourself. It's up to you to appeal.
Okay, no problem. I'll send a letter out today with a notice of appeal to the Supreme Court of the state of Washington.
Appeals from courts of limited jurisdiction, which is what we are, go to Superior Court, not the Supreme Court.
But I'll try to speak to them based on the circumstances that I would like to oblige directly to the state Supreme Court due to the circumstances and the fact that it's connected to a matter of national and homeland security.
You're gonna have to show them proof that that's the issue too. You can't just say a
I
thing
will,
and then
I
have it
will
be
show them
true.
the proof. I will show them the proof with no problem. It's on them if they want to do their work and research and diligence to get the answers that they want, that they seek.
So,
I
sir,
will show them the proof.
sir, once again, courts are not investigative bodies. They will do no research. They will not do an investigation. That is up to you.
I understand it, exactly, and I'm doing an investigation on my behalf, and I'm providing everything that they're asking me for. They just don't like my answers. I'll deal with that on the federal level when I file a notice to remove, once I get out of jail, because I can't do, also, if Mr. Ionetti, if you can file a notice to remove with the federal courts or with this court, I would like that as well, please.
Mr. Iannetti, do you have any concerns about Mr. Evans' ability to proceed?
I do. I mean, I don't have anything to verify any of the claims that he has made and the information and who he's asking for as far as witnesses in this case lead me to believe that there may be issues.
Do you think it's appropriate to have him evaluated under 1077?
I do.
Does the city have any objection to the ordering of that evaluation?
I have an objection.
Okay,
Can I object?
you can object.
Yes, ma'am. I assure you that I'm 100% competent, and I assure you that everything I'm saying is true. As far as civil case 24012 out of St. James Parish, Louisiana, that is a matter of secret state privilege, and it also verifies the facts that I'm making that you guys claim you cannot prove.
But you won't let us see it.
Mr. Ionetti has to get the case himself.
He has it.
So
I
tell
have
him
a
give it to, tell him
What?
give it to you.
I
Tell
don't know.
Mr.
Can I identify the case, Mr. Evans?
Civil case 24012 out of St. James Parish, Louisiana.
Can I identify the case and the information that I have?
Like I said, you can give her civil case 24012 out of St. James Parish, Louisiana. If she wants to look over it, it has a seal on that case. So you're going to have to get permission to get that seal removed.
So
to
it's my
get the
understanding
true
it does,
contents.
it's my understanding it does not have a seal.
That's the information that I have is it does not have a seal. It's a 1996 case, Blue Harvest Maritime versus Opal Evans. It was a suit for damages.
That's the guise that it's under, but the true contents of that case is under seal. I assure you.
And Mr.
I
Evans,
guarantee it.
the only person who
guessing.
can take it out of seal.
I'm not guessing. I'm guaranteeing it because I became the chief of a federally and internationally recognized tribe when my father passed in 1993, and everything was made official with that case in 96. I guarantee it.
So if it goes to me, it goes to the city as well. And are you okay with that?
I would like to have it sealed due to the fact that it's gonna expose innocent life.
It's a matter of
my own.
public, sir, it's a matter of public record. And it's not filed under seal. That I don't know what the justification is for sealing it in this court.
That it's gonna affect innocent life, including the names that he named that I don't want named with public, to have public access to those names on that case and whatnot. It's definitely gonna affect innocent life, and it's connected to a matter of national and homeland security.
Mr.
I
Iannetti,
guarantee.
what you were able to, what you have in your possession is a matter of public record. Is that right?
The information I just have is what the court clerk told me. She indicated that I can pay $1 a page for the file. They weren't able to tell me how many pages were in the file. They said it was archived based on the age. It is, it is a state court. And they indicated it was a suit for damages and not consistent.
It's connected to my estates that I have, plural. Is it all making sense now?
No.
And there's only, Mr. Evans indicated that there's something in the file that's only one person has the ability to unseal, which
And that's
is not
Chief
consistent
Justice
with,
Roberts.
and that's not consistent with the way the law works. So
I'm
that's
the
my
rarity.
concern.
I'm the rarity in this case, I assure you.
That's where my concern is. And I mean, the amount of money that could be for the amount of documents in the file, I'd have to ask if the court wants me to try and make that request to get that. I can make that request. I would need funds from the court, and I don't know how much. But a state case that would be doing what Mr. Evans claims is not consistent with my understanding of the law. And the fact that a chief justice is the only one that could unseal something within that case is also not consistent with my understanding of how the law works.
Particularly if it's a state case, I don't see how Chief Justice Roberts would be involved at all. Not to mention, it sounds like this predates him being Chief Justice.
Because it's a matter of secret state privilege, and it's also connected to the United Nations.
Sir, you have two choices, either to stop asserting this or get the document.
If Mr. Ionetti can get the documents, I would appreciate it.
The fact that you just say a thing doesn't mean anything. You have to have the proof.
The only way I can get the documents is for Mr. Ionetti to get it. Otherwise, I can't do it from in jail. If you could give me a PR bond, I would definitely get those documents for you myself.
The problem, sir, is you just keep committing new or alleged to have just keep committing new crimes.
Allegedly, but I assure you I'm innocent.
So were you able to obtain any documents, Mr. Ionetti?
Not without, I'd have to get funding from the court to obtain.
Got it.
And they said it was in archive. The person that I spoke to said it was in archive, and they were willing to go down and get it and make copies, but they said it's $1 a page.
Is it all or nothing? I mean, that you have to get the whole file or none of the file?
Because I don't know the answer to that question. I can try and see if there was a judgment out of that case that I can just get the judgment, but I don't know specifically what I'm looking for, because Mr. Evans told me that what I'm looking for is under seal that only Chief Justice Roberts can get me. And I don't think I have the ability to contact Chief Justice Roberts and ask him to give me the document out of that case.
If I'm lying about Chief Justice Roberts, trust me, these state charges, these petty charges are the least of my concern.
I can write a letter to Chief Justice Roberts, but I don't know what that will accomplish.
Can they tell you if anything is sealed?
I asked, and they said there's nothing sealed in that case.
Okay, well, that says something right there.
But Mr. Evans indicated, and is this okay that I say this, Mr. Evans, that what you want is only what Chief Justice Roberts can release?
Correct. It's a matter of secret state privilege. So you're gonna be able to see, but you're not gonna be able to see, so to speak, because the Supreme Court of the United States of America has it set up that way purposely for these type of purposes.
I'm not aware of them having this procedure.
Right, because if you're not familiar with the rights of a sovereign state and a sovereign tribe, you wouldn't know the ins and outs. But it's a matter of life and death that I know this and that I have the knowledge of what I'm talking about.
Mr. Ionetti, I would authorize funds for you to obtain the judgment. I'll give you up to $100. Okay. I am ordering a 1077 evaluation. I have concerns about Mr. Evans' ability to proceed. So this is on the court's initiative.
Is this going to delay my trial?
I'm leaving the trial date set where it is. Ms. Chenwiller, I'm assuming that there's no immunity agreement between you and Mr. Evans.
I would like to put one in place if possible, an immunity agreement based on the right, on the fact
Sir,
that
so this would be with regard to your conversation with the evaluator. It's not immunity from this case.
okay, so I have to speak with the evaluator.
To get this
Correct.
done.
Pardon?
City would not object to that to get this done.
Can I make an objection to that?
To what?
The order for the 1077.
Yes, and you have objected. I'm ordering it anyway.
Can I appeal to the Supreme Court or to the appellate courts?
I can't give you legal advice. I mean, I can give you.
Mr. Ionetti, I would like to appeal that decision that the judge made to the Supreme Court of the state of Washington directly due to it being a matter connected to national and homeland security.
I'll come and talk to you about how you file an appeal. Your Honor, and this is, yes, okay, the court checked the right box for this. So the city's indicated that don't have an objection to an immunity agreement. It doesn't sound like Mr.
And I also would like to have a notice to remove this case due to bias and prejudice to the federal courts, please.
That's not a basis to remove a case to the Supreme Court, I mean, to the federal court.
Bias and prejudice is not a reason,
No,
and violation of my constitutional rights as well, and civil rights. I think that would be a very valid reason, but I'll let you go with your decision if you failed, if you
it's
are.
up to you, sir, if you can file to remove it, and you
Yes,
do you.
Mr. Ionetti, can you please file a motion, a notice to remove to the federal courts based on violation of constitutional and civil rights, please?
I will come talk to you about how you can do that.
Would you like Mr. Ionetti there at the evaluation?
No,
Okay.
unless are we gonna be talking about anything legal?
I have no idea, sir. That's between you and the evaluator.
Yeah, if we're talking about anything legal, I want him there as standby counsel to explain my legal rights, far as my legal rights constitutionally and state-wise. But if it's just questions regarding my competency, I can handle that on my own. But once it goes into my rights and whatnot, I definitely need counsel available.
Mr. Ionetti, based on your experience, do they discuss rights other than informing defendants of their rights?
My experience is that they tell them that that they're going to write a report, and anything that they say to them is going to be included in the report. They ask them about their understanding of what the charges are and what their understanding of what the court's role in the case is. I don't believe they ask the person to give up any rights or do anything of that nature, typically.
If they're just asking me if I understand my rights and if I understand the charges, I completely understand that. I could tell you now, I'm being charged with trespassing, and the definition of trespassing, according to the state, is to enter a building without permission, unknowingly knowingly or.
That's okay. I believe that you know that what
If the
elements of the
court
charge.
wants to check the box that he wants us present, then that's fine, and they can notify us, and we'll make an effort to be there or schedule with them when it works out.
No, I don't want them there if it doesn't have it. If the questions aren't pertaining to anything legally, I don't want them there. If it's just questions regarding my sanity, I can do that myself.
Okay,
That's my understanding. The only legal questions really they ask is your understanding of the judicial system.
Well, yeah, I can do that myself.
okay. All right, I'm setting a return date for that of June 14th. I'm not striking the trial date at this time. We'll leave it where it is. So we will see you back here for the readiness hearing. Will be your next hearing, sir.
Okay, and the subpoenas, you said you won't be able to honor these
It's not a matter of honoring. I don't have the power. My power and Mr. Ionetti's power ends at the borders of the state of Washington.
Okay, would that be grounds for having this case removed to the federal courts, being that I have witnesses that will be able to testify on my behalf that you guys don't have the power to subpoena?
So it's no, the fact that witnesses are out of state is not grounds to transfer a case to federal court. The parties, it's a matter of diversity of the parties. That's my understanding of federal law. This is something you should discuss with a lawyer, though. I am not I don't do federal practice, so I'm not, I haven't really thought about this since law school, to be honest, but you can have this conversation with Mr. Ionetti.
Also, I would like Mr. Ionetti to file a motion to suppress any witness statements or
I'll explain to
testimony.
you how to do that.
Okay, but I'm putting it on record that I want the witness statements suppressed or any testimony that they're providing, because they have incentive via the case that I provided you, possibly to provide false testimony.
So a case that no one knows what's in it, and that's going to bias your witnesses?
based on the fact that they could be under non-disclosure agreements, which is kind of like what's going on with that case.
Okay,
That case is a matter of secret state privilege. So of course, you're not going to be able to just look at it and see exactly what's going on with it. Other than taking my word and contacting the Chief Justice Roberts, who will send superseding orders, as I stated in the letter.
I suggest that you write to Chief Justice Roberts then for assistance, because I don't know.
Once I go through the appellate process, I assure you I will, and I can assure you he's paying attention to what's going on.
Okay, all right. Well, we will see you back here then for readiness. Thank you, sir. Bail remains as previously set. Do we need a commitment order, Madam Clerk, or can the? Oh, you've got one in here, or I put one in here, I guess. Okay.
They don't mean to add to any difficulty, but the city wants to be sure that it is prepared and clear on its obligations. So the court is leaving the jury trials previously set. So we do have readiness on, was that June 12th we had set it for?
Yeah, it does come 2 days before. We'll likely have the evaluation.
Great. So the city will go through its normal witness list and subpoena process, just so the defendant's aware. He had mentioned or named Lance Little, Director of Operations at CTEC International Report, as a potential defense witness at the last hearing. We're not going to subpoena
And
that
also,
individual. Again, if he's a defense witness, that would be the allegation of the defendant, just to be clear on that.
I would also like to subpoena the Kitsap Airporter CEO that of the airporter that goes to the airport. Kitsap Airporter Charter Bus is the name of the company. Kitsap Airport. I would like to subpoena that guy as well.
Again, just to be clear, that's defendant's responsibility, and he would need to provide that information to the city as well.
Mr. Ionetti, are you taking notes?
I will come to you. You represent yourself, Mr. Evans, so I'll come to you and explain how you can get that done.
My hands are tied inside the jail.
I know.
I don't even have enough paper.
So, Mr. Evans, I'm going to come talk to you and give you the paperwork so that it can get done. And then once it's prepared, I can file it for you.
And so just to be clear, even though we are leaving the jury trial on because the court entered the order for the competency evaluation per court rule, the speedy trial is told. Thank you. And the city was ordered to provide discovery to the defendant. What, Mr. Ionati, do you know the best way to get to that to him in SCORE?
Is there, I think if there is, I mean, is there other stuff other than paper copies? Is there anything else other than documents? I
can
make a copy of everything.
There's a potential 911 recording. There's custodial statements I read that's involved as well. I don't have any of that. And I would like a full discovery, everything that the city or state's gonna use in the trial.
And you have a right to that, sir.
I haven't gotten it yet.
Mr. Miller?
I can print everything off that's printable. As far as if there's anything electronic is the only issue. I don't know what, I can go there and play it for him.
And also, what case is it that we're taking a trial on the 24th? Because I didn't get that information. That information wasn't specified either as well. So what
I know,
case...
and I said this, sir, at the time, we'll set all of them for the same day. And then based on witness availability and based on what makes sense, we'll just figure out which one goes first that day.
Thank you for clearing that up, Your Honor.
And I said, I'm just repeating myself, sir.
It never was made clear to me when it was officially done. So I thank you for clearing that up for me, as well as officially explaining to me what an affirmative defense was that Mr. Ionati couldn't legibly or competently explain to me, which is why I wanted him fired.
Mr. Ionati, I may need to email you then on when I review the cases further, if there's electronic discovery that needs to be sent to the defendant.
Okay.
All right, thank you, sir. We'll see you back here on the 12th.
Thank you.
I'm on mute. Can you hear me?
Yes.
Okay, are they dismissing everything, or do I still have the review cases?
Just 1 second, sir. Mr. Evans, just 1 second. We're in the middle of something. All right.
Was I found competent or incompetent?
No, Mr. Evans, we're not, this is talking about someone else. Now we're about to address your hearing.
This is standard.
Okay. And this is City versus Sylvester Evans.
It's Andrews that show on the blue line.
0820191.
Everybody can come out.
65525, 3A0549215, 4A0231898, 4A04725552, and 3A0312319. Have the parties had an opportunity to review the evaluation?
Yes. Yes, right.
Did either party take exception to the court adopting?
I have an objection.
Object to the court adopting the evaluation?
What's the status of the evaluation? Was it competent or incompetent?
I'm not able to proceed.
So that mean they found me incompetent?
Yes.
Okay, could I see the paperwork on that so I can review it and have that challenged?
So just to be clear, if you're incompetent, everything gets dismissed. If you're competent, then everything proceeds.
So that's what I'm asking. Did the doctor find me competent or incompetent?
Incompetent.
Okay, under what circumstances? What was his reasoning?
Delusional thinking.
And what proof did he have on that?
I mean, the interview that he did with you.
Okay, and being that you said everything is dismissed due to delusional thinking by law, from what I read at the law library, it said being delusional in itself is not reason in itself to be declared incompetent.
That you are unable to assist in your own defense because of it. So there are two prongs, there are two ways that you can find someone unable to proceed, that they don't understand the nature of the proceedings, which you clearly do, and the evaluator said that. But that you were unable to assist in your own defense due to the delusional thinking.
Well, that's being with the letter that I sent to you, that would directly refute that, correct?
No, that supports that.
What the letter I sent to you, it had motions that I wanted filed and whatnot that would prove that I'm able to assist in my defense, correct?
No, it was, you wouldn't give me any information. You gave me half information about things, refused to give the further information when I asked in court.
I did declare that the information regarding the evidence, that was a matter of secret state privilege. And then I also declared that the motions that I want to file, I didn't have access to the law library to get the proper documentations.
I am adopting the evaluation over your objection and finding that you are unable to proceed in these matters. So the pretrial cases are dismissed. All of the reviews are closed pending a further finding of able to proceed. The evaluator did not opine that you should be evaluated by DCR prior to release, so you're just released today. You can appeal this. You're welcome to appeal this finding, this ruling, and you could come to the court and the clerks can tell you how to do that, what paperwork to file.
All right, so I'll be released from jail today.
Correct.
And also, can I get the paperwork of the evaluation from the doctor?
You represent yourself, so I think you kind of have a right to it.
Yeah, how do I get that paperwork?
Mr. Ainati, are we able to print that out for him?
You can print it off and give it to the officers to give to them.
Okay, we'll get that to you today.
Okay.
All right, thank you, Mr. Evans.
And also, I want to put on record that I want to file a notice to appeal to the Supreme Court of the state of Washington.
That's appeals from courts of limited jurisdiction go to King County Superior Court.
I understand that, but I want to bypass the superior courts and go directly to the Supreme Court due to the circumstances and the nature of the judgment.
Okay, you can try to do that.
I want it on record noted. If you
you
have a,
you have to actually file it. That means nothing. You have to actually file the documentation. You have to file notice.
that's impossible to do from in here. You're saying when I get out, I have to file it?
Yes, correct. You'll have 30 days to file it.
Okay.
Okay. You should know though that you are still trespassed from the airport. Nothing in what I've done today affects that. That is the airport's trespass notice. It is still fully valid. You will be rearrested. Okay.
So even if I'm there on personal travel, I'll be rearrested.
You have to comply with their rules and restrictions. I'm not going to give you legal advice as to what that constitutes because you need to look at your trespass notice. But
yeah, I was there this time on legal business.
We're done. We're done with this case. This case is dismissed. So we don't owe me any explanations. I'm just telling you that the trespass order from the airport is still out there. Okay. I'm just letting you know.
Okay, so I can still be arrested under false premises because they also said I confessed in this case, which was not true.
I'm just telling you that the trespass order is still there. That's
okay.
all I'm telling you. Okay, thank you, sir.
Okay. Also, what I want to fire Mr. Iannetti as well.
He doesn't represent you. We've already gone through that. He doesn't represent you. You can't.
Okay, well, is he going to give me the paperwork that I need for these proceedings?
Score will.
Okay, and the evaluation as well from the doctor?
Yes, I believe we'll be printing that out. Mr. Iannetti said he would print that out for you.
Okay.
All right, thank you, sir.
Well, what is going on with the review cases? I guess I haven't heard that part.
They're all closed, pending a further finding of able to proceed. If maybe
closed. What does that mean?
It means there are no affirmative conditions no conditions can be imposed because there's a finding of unable to proceed.
So they can be reopened later?
They can.
So I can have a warrant placed and I don't even know it once again?
Well, no, you would have to get notice of a hearing.
Like this time I didn't get notice of the review hearing and they placed the warrant out for failure to appear. I didn't even know I had a hearing on the review charges.
This is why it's very important to keep your address updated.
My address is very, I don't know, for lack of a better word, I do a lot of moving around. So I don't have a steady address that I can always get mail at the moment. So that's how we got in this position the first time.
Well, so that sounds like, I mean, if you're not going to let us know how to get in touch with you, then you can't complain when you don't get notice.
I can give you an email. Would you be able to contact me by email?
And I think we have that listed.
But they never gave me a notice of any hearing via email.
Okay. We will make a note, email only.
And I'm still confused as well. The case is open or closed?
Closed. He's unable to proceed.
And I'm confused by that. So the conditions were imposed. There's an allegation that he violated him. He's not found competent. We can't move forward in those violations, but it doesn't invalidate the conditions that were set because those were done at a time that he was competent. Like, is the court still taking jurisdiction? Like, I'm still struggling with that.
I can't impose conditions.
The conditions were already imposed, though.
I know, and they're stayed. Everything is stayed.
Sure.
Like,
but so the case is open but stayed, or is it
I guess
closed?
that's a better way to characterize it, but it's for all intents and purposes closed, effectively, pending a further finding of able to proceed.
And also, would I be able to subpoena any grand jury proceedings that may have taken place as well?
There are no grand juries in courts of limited jurisdiction, and I don't believe there are in Washington at all, other than federal.
Okay. And so you said, yeah, I'll get a copy of the evaluation, and you say I got 30 days to start filing motions to try to get everything reversed, right?
At this point, your only avenue is appeal.
Correct.
Okay. All right. Thank you, sir.
So I think the city is objecting to the meeting closed in any way.
So they're not closed. They're just, I mean, I thought we talked about this.
I know, but when we're using words like closed, is there going to be a CL for
No.
closed disposition?
No.
Because that's what's going to be in the docket is they're closed. And so in a year or two, if this comes up again, it's going to be very difficult to figure out what exactly happened today if we're
Well,
using
in 2 years, it's too late. Jurisdictions run.
Sure, there's some situations where that wouldn't be the case, but so the cases are open is all I'm trying to understand.
Yes, they are not closed. They're just.
Okay.
Okay, so would you be able to clarify that for me, Miss Your Honor, in layman terms, so I can get an understanding, because you're saying it's not closed, but it's open closed, which is kind of difficult for me to understand.
I am, you guys are right. I should use more careful language. The cases are open. They are stayed, which means frozen, essentially, unless there's a further finding by a doctor that you are able to proceed.
Would that be able to be done in the appellate courts or the state Supreme Court, or overturning his findings, or what? How do you get the proceedings to be found? How do you get that overwritten, basically, with the doctor prescribed or diagnosed?
So, and this is interesting. It's a situation I haven't come across where there's an individual wanting to contest the finding.
Yeah, based on, I don't have the law library's information in front of me, but based on the information I got from the law library, the defendant cannot be declared incompetent by being delusional in itself.
And
That's
I explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator. Am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way, though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
The stuff about the case in Louisiana.
I asserted evidence that has a seal on it. So the only way he can find out that it doesn't, what I'm saying is not true, is to get the seal broken on the evidence, which is under state secret privilege. And the only way you can get that broken is by orders of the president or Chief Justice Roberts of the United States Supreme Court.
So when you get all your ducks in a row to get that happening so that the court can see it, it sounds very far-fetched. I've never heard of anything similar happening on a state case that the U.S. Supreme Court would involve themselves, much less that any one justice would have authority to unseal something. I'm adopting this finding. You can appeal.
Is everything that we spoke about today on the record? Would I be able to get recordings of all the subpoena recordings of all the hearings, including what we're talking about today?
They are all online, available for you to listen to anytime you want.
Okay, and they all can be subpoenaed by the state Supreme Court and whatnot to be overturned or sealed.
They are not going to do any investigation on your behalf. If you're appealing, you have to do all the investigation.
Right. No, I don't need them to do the investigation. Everything's pretty much said and done. The only thing is the assumption that you guys don't believe the evidence is under state secret privilege, and I am who I'm telling you I am. So you're believing I'm delusional. Am I correct?
That's correct.
Right. So y'all making assumptions that's not true, that I have to go through the process and get everything removed to the federal courts to prove that it's true, which is going to be under seal at that moment. But I'll give the state Supreme Court a chance to make the adjustments and override.
Okay. Thank you, Mr. Evans. You'll be released today and you can get working on all that. All right. Thank you, sir.
All right. So we're done here?
We're done here.
Appreciate it.
Well, guys, we have come to the end of these two proceedings and the end of what seemed to be a very long and drawn out case for those of us that saw all 5 appearances by Mr. Evans. Before we address how this thing concluded, let's just talk about that first appearance, which was his 4th appearance in this video. We see him, wanting to subpoena a lot of people, obviously, that he could not subpoena, that wouldn't be able to be subpoenaed. We seen him still going hard on the chief thing and being the chief of the sovereign tribe. And then we also see where he constantly kept saying how he understood certain things that he didn't understand, because we find out that the case that he was trying to use to prove his innocence, or to prove whatever it is that he was trying to prove, was a case of public record, right? Like it was a matter of public record, like anybody could see these documents. But he kept talking about how, they needed to be unsealed by someone. But the fact that she kept trying to explain to him, listen, this is a matter of public record, and he wasn't even really getting that, just showed how much he's going through in his mind, how much he's struggling with mental health, right? And another thing that we see that I thought was wild throughout these proceedings, was how many times he tried to throw Mr. Iannotti under the bus. I mean, if you've been following this case, many a times, no matter how much poor Mr. Iannotti tried to help him out, he's tried to fire him. He even tried to fire him after finding out that, listen, your case is going to be dismissed or put on hold. We're going to let you out today because you were found incompetent. And that's what eventually happened, right? Because he couldn't understand for certain things in that 4th appearance, they ended up doing the competency hearing, and he was found incompetent, right? Because his delusions was impeding his ability to help defend himself. So even then, he's still trying to appeal, like, listen, brother, this is what you've been trying to do. You've been trying to get out of here. But yet, because of what he's going through in his mind, and also I don't think it's only because of what he's going through in his mind, but I think he absolutely wants to prove, like, listen, I'm not delusional like you guys think, because obviously he believes a lot of the things he's saying. So he, he's not even trying to grasp hold of, you can get out of here today, even though he knows. And if you remember what she said about the doctor, like the doctor said, he clearly knows what's going on. He clearly understands what these cases are about. And if you notice, when he first jumped on, he was like, is everything going to be dismissed today? So this whole thing was very weird. I'm just as confused as the prosecutor was. Yeah, this was a wild case. I've never seen anything like this. Like, I wouldn't have been surprised if he would have, just right before he got off camera, like, I told you I was the tribal chief. I just wouldn't have been surprised at anything happening in this case after seeing how all of this played out. And the poor judge, man, every time she tried to dismiss and just close it down, either Mr. Evans or the prosecutor has something to say. But I will say this, man, it's definitely nothing funny about mental health. I don't think that's a joke. I don't think what we see Mr. Evans going through is a joke. Going through in your mind is a very serious thing. And believe it or not, many people struggle with it. Maybe not on that level, but just everyday people, because of the stress, because of the different things that this life brings, they're going through their own mental health and spiritual battles in many different ways. So I didn't find any of that comical. I definitely found certain things that happened in the case comical, but I never think anything that somebody's going through in their mind is a comical thing. But prayerfully, this guy, he stays away from the airport, because they clearly don't want him there. And whatever is going on between him and the airport is probably whatever he's going through in his mind. He used to work there. They didn't really say. He has some type of connection to that airport. There's something going on where he just feels that he needs to be there, because if they're constantly saying we don't want him here, then that means he keeps popping up there for some reason. So there's probably some type of connection in his mind to that airport. But like I said, prayerfully, Mr. Evans gets the help that he needs. He goes on and does what he needs to do, but this case is still there. So if they do find him competent down the road, they can open the case back up. But with that being said, guys, I appreciate all you guys that hung in there for the long haul. Thank you, thank you, thank you. This is Sovereign Citizens Hall of Fame, and it is always a blessing to have you guys with me. And with that being said, guys, once again, this is Sovereign Citizens Court. And for now, guys, court is adjourned. God bless.